Yes.
You want to come in?
For the record, Chris Bolt, Donahue, Tucker, Chandela, down in Meredith.
And just before you start, I just want to give a little summary to the crowd, if you don't
But
mind.
do you want to sit? No,
Either way,
you can sit at the table.
Yeah, of course, you can sit right there.
Yeah, no, go ahead and sit down. Yeah. And if Ms. Gaudette wants to join you, that would be fine too.
So I just want to say that I want everyone to understand how we got here and what the board is looking at. This is an existing unoccupied structure located 15 feet and 13 feet from the side property lines. At the time it was built, it was legal because unoccupied structures could be built within 10 feet of the property line. So it met that requirement. They're now seeking to change the use to make it an occupied structure, which means they need to meet the 20-foot setback, which they don't, so they're seeking a variance. That variance is only for the setback and only because it's going to be occupied. This board is not looking at whether short-term rentals are permitted in the structure, on this property, as an accessory use, any of that. This hearing relates solely to the 20-foot setback for an occupied structure. So I just wanted to make that clear for everyone because I know there's been a lot of confusion about exactly how far we should be delving into those issues, but that's the issue the board is going to deal with today.
So, and we'll have you address that, I presume, or Ms. Gaudette, but the primary issue, as she says, is that there is a section that requires any occupied structure to be within, have a 20-foot border from the sides, 20-foot setback. And they are requesting to make it an occupied structure. The purpose of the occupied structure is irrelevant, and they want this structure to remain as within that setback and be used for occupation. That does not mean a dwelling, just occupation.
That's not necessarily, right?
Yeah, not necessarily mean a dwelling.
Right.
Go ahead, Mr. Bolt.
Thank you, Madam Chairman. Again, for the record, Chris Bolt. I have copies of the photographs that we tendered with our application. I did not know if the board members had copies already.
No, I have not seen them.
Yes.
She's not ready to see this. Because we have five.
Maybe not.
Okay, full compliment.
No, you won't need to be seated to vote.
As indicated, we are asking for a variance pursuant specifically to a letter that we received from the code enforcement officer back in July that was indicating we obviously could not use the structure as desired without coming to you for the variance. The variance is pursuant to Article 4.A.1 little e Roman double I. The structure as explained and as is shown on the plot plan that is based on your tax map is the rectangle at the lower quadrant that is at the end of an existing driveway. It is 13 feet off of the property line with the winds.
Excuse me, I can't see this. Can that be put on that side by any chance so we can see what he's?
If you wish, it's very, here, let me show it to you.
Yeah.
But it's more important for them to see.
Well, we all have a copy of your variance.
Okay, where would you like it then?
And I make it so that they can see it also. So that the audience here can see
Maybe
it.
right back here.
Yeah, back there.
Sure, wherever you wish.
Why don't you put it back here?
Thank you, sir.
David?
And it is in the quadrant of the property that obviously angles out slightly in front of the wind property. That structure is from the foundation about 15 feet from the boundary line, 13 feet from the eve line. Nothing is happening to the structure itself from the outside. As the photos reflect, it has this driveway There is a slider on it. There are windows. There's a door. It looks very much like a where someone would live versus the shed for the lawnmower and the snowblower. So nothing is changing from the outside. What is changing on the inside is that open space will be made into 1 bedroom, 1 bathroom, and a kitchen area with open space. There is a unfinished basement on this building already. Nothing's going down there. That's remaining for storage. From a standpoint of permits required, DES is not going to have an issue with this. It's located sufficiently far back from the West Branch. This is also intended to be connected to the town sewer system. We've confirmed that we can make access there. So right now, the main building, the main house is serviced by an on-site septic. So we're saying we would connect the house and the structure where this change would occur to the town sewer. The 5 variance criteria that you're used to dealing with, you start with spirit of the ordinance. Will the variance not be contrary to the spirit of the ordinance? And as the courts have told us over the years, you look at the particular provision of the ordinance and what is the change that's being asked for, what's the relief that's being asked for. And is that variance unduly and in a marked degree conflicting with the stated purposes of the ordinance provision in play? And here I would argue that, again, as the court says, you look at, is there going to be a significant change in the nature of the neighborhood by allowing this? Or is there going to be a threat to health, safety, and welfare by allowing this? When I give the lecture over the years to ZBA members through either the NHMA or the OSI, used to be called the Office of Energy and Planning, my example is the change of the neighborhood is putting a convenience store in the middle of the residential zone. That's a change of the neighborhood. Here you have a existing structure that can be used pursuant to your zoning ordinance by short-term rental. And there's going to be no change of nature to the nature of the area, this neighborhood. A item that would be of the nature to be a risk to health, safety, and welfare, putting the propane storage facilities in beside residential structures, something that can go boom pretty badly. That could be a threat. Putting a slaughterhouse or something that emits a lot of odors could be something that could trigger that. Again, this is not going to have any of such effect on the neighborhood, especially when it's considered to be an allowed use and something that we can connect to the town sewer. The second prong, spirit of the ordinance, is observed. The court tells us we're supposed to view that criteria really the same way we look at the first. In fact, the court has told us you don't want to say yes to one and no, but it is the same criteria, same standard of unduly and in a marked degree. Substantial justice is done, is your third prong. That is the balancing test. You have, the court has told us over the years that you are the court of first resort and you are really the constitutional safety valve, because we respect the rights of property owners to do with what they wish to their property that they're paying taxes on. Coupled with that, there is an interest in regulating uses in a zoning ordinance. So those two things are intentional. So you are trying to balance those two tensions. And the court tells us that balancing is best done by looking at the harm to the owner to infringe upon their property value. Has to be outweighed by some benefit to the public that is coming from the denial. And if you don't have that benefit to the public, and just upholding the zoning ordinance because they wrote it that way is not enough. There has to be something material that is of benefit to the public for denying this variance. If there is no such benefit, then the applicant meets that prong of substantial justice in that balance. Fourth is there will be no diminution in surrounding property values. There, the court looks at what's the nature of the use being sought for? How do we look at what's going in here? In this particular instance, you have an existing structure that is not being changed from the outside. You have an existing driveway that is not being changed from the outside. It is where it is.
Yeah, Chris,
Could I just interrupt for 1 second? Because it's the second time you've mentioned it. There is no permitted existing driveway. So
the
that,
driveway might exist, but there's no permit for it.
Okay, that's news to us.
Yes.
yeah. So it can't be called an existing driveway yet.
Well, it exists, but I understand that there's not a permit.
Right.
We were unaware of that. And thank you for raising it.
Sure.
My question would then become, you've owned the property for how many years? Okay, so do we know when that driveway came in?
I assume it was when the building was constructed.
Which
I don't
is-
know any more about it. Mark mentioned it earlier today, and
Okay.
it's something we'd have to look into.
Yeah,
We have to look into, but
Yeah.
if it's a nature of a permit,
yeah.
Situation.
It's a driveway permit.
right,
Yeah.
and that's fine. So I would suggest, just like our suggested condition of approval, that this be tied to actually getting the sewer connected, have this additional bit of news be
I'm on it.
an additional condition of approval,
That's
that
fine.
we have to get the permit before we can have a certificate of
Yes, we understand.
Thank you for the clarification. We were talking about no diminution of surrounding property value. Again, because the structure is there, it is where it is, and it is not changing from the outside. That is not a diminution in surrounding property value. Were we coming in and building this, that might be an issue, might well be an issue. But it is where it is. We're also amenable, if needed, the existing screening that you'll see in the photographs stops about at the corner of the building. If the winds desired it and this board required it, we're amenable to having the shrubbery continue down that aisle. I'm not sure it's needed because the building's already there. But if that was a condition of approval, that's something that can be readily done. The fifth and final prong, as you know, is the unnecessary hardship prong. There, the court tells us we're supposed to look at special conditions of this property that distinguish it from others in the neighborhood and the provision of the zoning ordinance that's in play. Here, special conditions exist not only with the size of this lot being approximately twice what's needed in the LDR zone, but its configuration. This, instead of a straight rectangle, it has this odd hip flange that comes out where this structure is located. It has over the required amount of square foot or road frontage foot by 231 feet or so. The special condition includes that as-built building. We hear that from the Harborside versus Parade case. That was actually the first case back in 2011 on the change of the criteria when we got rid of BOSHA. BOSHA, those of you who may have been around long enough to remember, that was the court-appointed, court-created standard that put necessity into the mix. The legislature did not like that. They got rid of the BOSHA standard. So necessity is not an issue of the variance criteria now. What's now at issue with the unnecessary hardship prong is reasonableness and the special conditions of the property. We submit that because the language of your ordinance has a 20-foot setback for occupied structures. And this one is between 15 and 13 feet from the boundary. The issue at hand is a normal setback issue of why do you keep buildings apart from each other? One is provision of light and air. One is prevent fire leaping from building to building, things of that nature. And here, those types of issues, those types of concerns are not really infringed by the change of the interior use. You have the building where it is. You have the driveway, albeit unpermitted, where it is. On that quadrant of the property that's a little unusual with that tip out flange. We have the ability to connect to sewer. Not all of your properties have that. That's a special condition of this property. It is one where another authority will have to say grace on the intended use of short-term rental, and that's your select board. But your zoning ordinance says that this is an allowed use in this zone. And our court has said, starting way back with the Vigent case, that when a use is allowed in the zone, it is presumed reasonable. So we believe we have met the 5 criteria. We ask for this variance with the conditions that we've offered, both the connection to sewer and the driveway permit. And I'm here to answer any questions you may have.
Is there anybody on the board that has any questions for Mr. Bolt? Barry? Can I have just a minute to?
Of course.
I've taken a few notes and I might have a question or two that I might want to raise. When you were discussing the spirit of the ordinance, and you indicated that this is already, a structure that's there, and it is used, that it is currently an unoccupied structure, but you want to make it an occupied structure, which is one of the things that you want us to address. You indicate that there will be no significant change to the neighborhood. But this is for low density residential that is considered to be a very special, limited use of the property for a dwelling on the property. And don't you think that having a second dwelling that close to the property line, or even not that close to the property line, but that close to the property line, would make a change in the neighborhood and in the surrounding community if everybody did it?
First and foremost, your zoning ordinance does not make that distinction. The zoning ordinance allows short-term rentals in the zone, in the LDR.
But we're not looking at short-term rentals.
I understand that from a standpoint of, but your provision of occupied versus unoccupied is where that comes in. So it's one where your zoning ordinance language, if we were 20 feet away, we wouldn't be here. We're 15 feet away from the foundation, 13 feet from the eave, because this, by the photographs, has a fairly deep eave. So that it is definitely one where we 20 feet back, we wouldn't be here. We'd be only in this line. And that's a permitted use.
True, but you want to take an unoccupied structure and turn it into a non-conforming structure, into essentially another non-conforming occupied structure, because a variance doesn't take away the fact that it would be non-conforming, I don't think.
No, but
does sort of.
It
Yeah,
does.
It does sort of, okay,
It
yeah.
in essence gives it the imprimatur of,
Right, okay.
it's there for that change from
Uh-huh.
unoccupied to occupied.
Right.
It is conforming now,
Mhm.
period.
Okay,
It is non-conforming by our request to have it be occupied.
And it's
no,
actually.
it's still considered
Yeah, it's
non-conforming.
non-conforming now because they added in a size restriction for buildings that can be 10 feet. It's now 150 square feet.
Okay,
it's
so
non-conforming.
that's a subsequent change
Yes.
And it's
from the time it was originally built.
Right.
So it was conforming, so it's
Considered
fine.
non-conforming.
It's non-conforming
Yeah.
based on its size of 750
Right.
square feet within 15 feet, 13 feet
Mhm.
of the side.
So the question still, I think that all of us are looking at is whether an occupied structure on a low-density residential plot would change the character of the neighborhood. And
And
you're talking about this one particular use,
sure,
but we're talking about it because,
sure.
Yeah.
It's an interesting theoretical question, Your Honor, one that I think has been refuted by the Supreme Court in some recent decisions. You're raising an issue that was raised in Bacon v. Enfield, which was, if you recall, in the Boscia time period, a case where someone wanted to add a 4.5 by 5 foot shed for a new furnace on the
Right.
back of a cabin on the shores of Silver Lake in Enfield. And the plurality decision, meaning there was not a majority, they had one, the Chief Justice wrote the opinion, two concurred on different reasons, and two were in opposition. And one of the concurrences was the cumulative effect concept. And recently, the court in,
Peralt versus New Hampton.
yes, thank
what
you,
was that?
Peralt versus New
Peralt
Hampton. It was my
versus
case.
New Hampton. Basically called that into question, that
Okay.
it's a concurrence, therefore it has no value.
Right.
And we haven't wanted to go that far
Mhm.
as a court.
Right.
So I don't think well, if this happened, everybody would do it because so few folks have the existing structure is the,
Well, if somebody
Many of
closes
them, many of
down,
them have
then
existing
people-
structures. If you've gone through the neighborhood. Oh, I'm sorry.
They'll get their chance.
yeah, thank you.
I didn't mean that. I'm sorry.
But from a standpoint of, these are special conditions. This property has this structure and this configuration of land. Looking at your tax maps, I don't see this anywhere else. Looking up the street and down the street, I see one building north by about 2 lots that has something close to the front, but I don't see it in a side setback. 2 or 3 lots south of this one, there's a white structure that looks to be the only structure, if I'm looking from the drive on the same riverside. But the neighborhood as a whole, you don't see a lot of this configuration. So when you as the ZBA dealing with a variance, the court has repeatedly told us one decision does not make a precedent for somebody else because of those special conditions. And land is unique. So I would suggest to you, and you have able counsel here, that you have, if you went and granted this with the conditions that we have suggested, that has next to no bearing on the next time somebody comes in front of you. When they say, oh, you gave the go, that's, I'm sorry, their land has to meet the conditions as well. They have to make the argument that they meet the 5 conditions.
But as long as they have the existing structure that is within the setback, an accessory use structure, they could say, well, we already have this existing structure. So that therefore means that we should be able to change it follow what you did in the audit case.
They'd have to be smack on with us. And I've been doing this for a very long time. I seldom see the same case twice. Everything's friggin' unique. But I won't tell you it couldn't happen, because always and never are seldom correct. But it's one where I think you have to look at us with the 5 criteria in play. And do we meet the 5 criteria? Being blind to what somebody else may or may not wish to do in years to come. The zoning ordinance, how many times has your zoning ordinance changed over the last several years? The zoning ordinance may well change again to say, instead of occupied 20, occupied 100, occupied 5. We don't know what the voters will do. We never know what the voters will do.
That's true.
So I would suggest that we look at this case as this case with the criteria the court has told us to follow.
Okay. Thank you.
Sure.
I don't know that I have any other questions for you, Mr. Bolt.
Thank you kindly. I'm here if we may have the opportunity to make some comments after everybody else has spoken, that's fine. But I appreciate your time and attention.
Okay. And I'll open the floor to anybody else that would like to make a comment.
Shall we go back to the row? I think.
Well,
would be
yeah, you
best.
might have, we seem to have a shortage of chairs.
Fear not, I
Oh.
can stand.
Here's some more over here, actually.
You take there. I'm standing.
Thank you, Dave. If you want to just grab one, too. One, I guess, this is all that's needed.
Well, if no one's gonna speak, I'll speak. My name is Mike Aaronson. I live at 71 Boulder.
Mr. Aaronson, I think.
You want to come forward, Mike?
Up this table.
Yeah.
Hi, my name is Mike Aaronson. I live at 71 Boulder Path Road. And I have a very similar situation to this house. I have a garage that I had to build within the setback. I believe I'm 12 feet from my neighbor in the same zone. I live up the hill from this property. And if this is to pass, I could come here and take my garage and ask to put a second floor, develop my second floor into an apartment for rental.
Mhm.
So I don't think it is unique to this property. I'm also a realtor in Waterville Valley. And I think it will change the character of the neighborhood and will affect property values. There are some instances right now where Airbnbs in the neighborhoods are affecting values and creating new concerns in town, such to a point where the town had to work on adopting new guidelines and zoning as far as controlling Airbnbs. So I just wanted to get that on the record, and thank you for your time.
Thank you very much.
Thank you, Mike.
Yes, Wendy?
Hello, Wendy Rathgar. I'm a bit confused because at this point, what they're talking about creating is a detached accessory dwelling unit, which is not permitted in town.
Mhm.
And I understand that the point of today is to address the setback, but I don't understand how, if the setback is allowed a variance, how that doesn't allow the.
No, that was one of the things that I had to bring Laura in for, because I wandered around the various zoning ordinances. I kept saying, this is not a permitted, it's not permitted. There's no planning board, and there are no ordinances that allow a detached dwelling or building, which would be made into a dwelling, a detached dwelling, be used as a short-term rental.
Or
in
because
low,
there's anything, an in-law apartment, there's no
Yeah.
detached accessory dwelling units.
Yeah.
allowed.
in low density
Yeah.
residential, yeah.
Yeah.
So yes, but she has focused.
We are
us-
not saying that that is or is not permitted. We're not saying short-term rentals are or are not permitted in this building. We're saying it may be occupied. Occupied could be an office. It could be a playroom. It could be occupied in various different ways. So we're not blessing, if
No.
this variance is granted, any short-term rental or any dwelling in the property. The
There-
zoning board is saying you may have an occupied structure in the setback and everything else is going to go back to the selectmen and they're going to have to decide what if any other variances might be required.
So we would, our only thing is to say, okay, we don't have a problem with this meeting the variance requirement if you want to use it for an occupied use. But they're gonna have to, they cannot then build it and make it into a short-term rental because the short-term rental only goes to existing buildings. So they would have to go back to the selectmen and get a change of use. They would have to, taking into consideration it's non-conforming and they want to change the use, which is prohibited. The fact that there is no existing ordinance that permits a detached building
Right.
to be a short-term rental. I mean, there are many things, many hoops that they will have to jump through.
So you're looking at that it could be used for a home occupation, but not as a dwelling unit.
No, not a home
We are not
occupation.
saying anything,
Nothing at
we're
all.
not saying anything about what use may be made of the building.
Yeah.
We're just
Okay.
saying it may be occupied
Yeah, so we,
if the variance is granted.
we would not say that it can be used for home occupation. We're not saying, because that's a change of use. I mean, that's the select board that will make that decision. The only thing we're saying is that it can be occupied if there is any permissible occupation, I mean, any permissible ordinance that permits it to be occupied. But we're not saying that we're making any decision whether there's any ordinance out there that does allow it. Because they're gonna have to go through all the other ordinances that might bring something to prohibit it on and deal with those with the appropriate person, whether it's a code enforcement officer, whether it is the individuals that make determinations as to driveway permits and what has to be done to make a driveway into a, permitted driveway. We're not doing anything that has to do with short-term rentals or change of use. That is all different other boards that do that.
All right.
Would you like to speak, Joe?
Yes, please.
Thank you.
I'm here as a
I'm sorry,
citizen.
I don't think we identified Wendy. This is Wendy Rathgar who,
Yeah, she did.
oh, you did. I'm sorry, I missed that. Okay.
Joe Lacasse, 16 Davos Way. I'm here as a citizen, not in any official capacity.
Okay.
I listened to the application, and I do contest some of the assumptions that he's made. The fact that it would not change the character of the neighborhood. When you do anything like that, when you're adding, apartments onto another lot, that close to the road and that close to another property, I contend that it will actually change the character of the neighborhood. And I also contest the fact that he doesn't think that this will bring future property, other properties won't try to use this to their advantage and try to do the same thing over and over again, because absolutely, this is another crack or a chink in the armor, and it will definitely open up the way, every variance opens the gates farther and farther, and they're asking for a variance for a reason. They currently can't build the structure. They can't do what they want to do with the structure right now because of the variance, because of the way the rules are set right now. I beg to differ that it wouldn't affect the neighborhood or the property values. When you look at that structure and how close that is to the property line right there, and then you look at how close, it's actually closer to the building next door than it is to the structure that's on its own property.
Oh, yeah.
I think that significantly would affect the property values of their next door neighbor. Let's see here. I did not know the driveway wasn't permitted, but it is not. He actually mentioned that this was not an abnormal setback for a neighborhood. The setback on that building right there, the way that is on the property, that's definitely abnormal for that neighborhood. The character of that specific neighborhood. It's not, I don't understand how that would fit in any consideration for a variance at all. Thank you very much. I
Thank you,
appreciate
Joe.
your time.
We have anybody else, Rich?
All right. thank you.
Okay.
Thank you for this opportunity to speak. My name is Dan Ring, live at 125 West Branch Road. I guess my first question would be talking about whether this would set a bad precedent. So if I wanted to build an accessory building on my property, if I met all the requirements and I got my building permit and I built it, a year later, I said, gee, I'd like to have this as a 1-2 bedroom apartment.
Mhm.
Couldn't I come in and apply for a variance to do that?
Well, I don't know that we could give a variance immediately. I think that you wouldn't because. you
No,
wouldn't-
I mean, the year after I built my accessory building, couldn't I, that based on this, if you approve this variance, couldn't I come in and say, all right, I've changed my mind, I don't want an accessory building.
No.
Each variance is limited to its own merits, and currently the zoning ordinance only allows an accessory building of 150 square feet within 10 feet of the property line. So that is the maximum you could build today. But we hear what you're saying. You're concerned about the precedential value.
Okay, thank you very much.
Mhm.
And counsel for the applicant mentioned that there are 5 criteria for granting a variance. I believe this application doesn't meet any of those criteria. If I could read from my notes,
Mhm, go ahead.
and I want to address each of the 5 criteria. The request violates the basic objectives of the zoning ordinance. This house and accessory structure are situated in a low-density residential district, but the proposed use would increase density. It is not even a residential use. It would be commercial rentals. The proposed use would therefore alter the essential character of the neighborhood. Further, the application states that this is an allowed use in a low-density residential district, which would not alter the essential character of the neighborhood. This totally misreads the zoning ordinance. The zoning ordinance says renting 1 or 2 bedrooms in an owner-occupied dwelling for transit use with approval as a home occupation. In is the key word. These would be rooms outside of the owner-occupied dwelling and therefore are not even contemplated or allowed by the ordinance. Number 2, the spirit of the ordinance is observed. This request is clearly outside the ordinance objectives, as it is neither low density nor residential. Number 3, substantial justice is done. Does this request cause harm to the general public that outweighs the benefit to the property owner? This request changes the character of a really nice neighborhood by essentially introducing a mini motel and that hurts existing residential owners. There are many areas in Waterville Valley that allow this type of use. The applicant bought a single-family home and is now making requests that would harm the neighbors, introducing traffic and people less concerned with the well-being of the neighbors as they are only short-term renters. And, while we're on the topic of safety, that one-lane bridge between Triple I Road and West Branch Road is very dangerous for pedestrians.
Mhm.
Not so much for cars, but especially during ski season, you have cars going over that one-lane bridge. Very dangerous for people carrying their skis. Accident waiting to happen. Number 4, the values of surrounding properties will not be diminished. That's another criteria. But this application is an attempt to circumvent the ordinance and to add density where it is not called for to the detriment of the neighboring property owners. The applicant bought a single-family home and now wants to create a separate, non-accessory commercial use. Little enforcement of the ordinance will result in an unnecessary hardship. The applicant's memo stating that there is no purpose defined for the setbacks entirely ignores that this is a low-density zone. Allowing owners to build to the margins of their property defeats that purpose, which the applicant is overlooking. Nothing is unique about this property that is allowed to host two primary uses, a single-family house and a separate commercial rental building. The applicant's allowed to use a single-family home, so there's no unnecessary hardship created by denying this request. Thank you very much.
Thank you very much. I think that you have a lot of good comments, and I think that there's going to be a time when this is before the select board that you'll probably have an opportunity to raise them again.
Well, I would hope it would not go to the select board.
Well, even if we grant the variance, they'll have to go to the select board.
Right, so I'm saying don't grant the variance, please.
Well, if we deny it, then they don't have to, yes, but it depends on what we determine after we've reviewed all of the evidence.
Will the vote take place today?
It may or may not, I don't know.
Okay.
There's a lot of things to consider in this particular application, even though it's very limited. So
But it will take place in public.
it will take place, yes, it will definitely take place in public. We will consider, after this hearing is closed, we will consider for a while. I mean, there will become a time limitation for us, and we will just then reschedule it for another hearing at a later date.
All right, thank you.
Mhm. And then- Okay, yes, go ahead.
My name is Patrick Nguyen. I live at 141 Scout Lane. We are the closest abutter to this property.
Right.
I'm kind of taken back here. I got a flyer left on my door Thursday night.
Mhm.
I was down in Florida. I drove back all night. I haven't been asleep yet. My wife and I canceled our vacation plans with our family down there to be here. Now, I wish I could bring my own professor in here and be as eloquent as he was presenting the case.
Mhm.
I'm not a good speaker. I'm not a legal professor. It seems like you guys have already kind of made your mind up that you're gonna pass this along and let it fall to the selectmen. I hope that's not the case. If that is the case, I want to bring my own lawyers in here and present my case that I have.
Okay,
Everyone here made great cases about why this shouldn't be here.
Yeah.
We've lived here since 2000. We had a place in Villages. We lived in the Villages. We lived at Black Bear. 5 years ago, we bought at West Branch, an elegant area, Tom Corcoran's original house.
Yeah.
You go down that road, you see beautiful houses, see the mountains. And now we're gonna put an apartment there. Now you can pass the buck and say, no, it's not gonna be apartment. We're just gonna let it be a occupied building. We all know what the end game here is. You know, help me. I mean, I feel like I'm caught off guard here because I get a flyer in the mail saying, show up and this building next to you, which is an eyesore. And when it just, I'm at the mercy of this board here. Please help us.
okay,
The town, the neighborhood there is a great neighborhood. Let's not change a character and my property value.
okay. There are a couple of things, and I'm sorry that we broke into your vacation, that this particular hearing did. The problem I think that you face and many people have is that the application goes way beyond what the board actually can do, what this board can do in making a determination as to a variance of the setback.
Why do we have laws and things that are approved and then people just go and say, okay, I have a good reason why I want a variance, and you just get a variance? Why are the laws there in the first place then? To protect our values and our property and our way of life on that road.
Because we have the authority to issue a variance with regard to that setback, that's all. We don't have the authority to determine whether the building can be reconstructed as they want. We don't have the authority to determine
That
what,
setback is there for a reason, right?
yes, it is definitely there for a reason.
So why would someone just come up with any kind of, what the board would say, a decent reason?
So,
My lawyer would like to address this.
so it sounds cliche, but in New Hampshire, the Supreme Court has held that the variance is the constitutional safeguard to make sure that zoning ordinances don't become a taking of someone's property, right?
Yes.
There are certain situations where the ordinance, as applied to a particular piece of property, just doesn't work in New Hampshire because we have an increased constitutional right to use our property. But in order to get a variance, you have to demonstrate the 5 variance criteria. And I can assure you this board has not made up its mind yet
Okay.
as to whether or not those variance criteria have been met.
Because I can guarantee you that if someone comes to my house and I say, oh, there's a workshop there, they hardly ever use it, that driveway's never, there's never cars in that driveway. If there is used as a workshop that it is now, they're there during the day. And then, so that's one value, right? And then I say, oh, no, that's an apartment, or there's cars there all the time. My property values are gonna go down.
We understand that that is your belief, yes.
That is,
Yep.
that's one of the issues that we have to look at.
I'm not a good speaker. I get nervous.
No, you're not.
You're doing
fine.
great.
You're doing great,
Apologize.
actually. You're being very articulate. You're being very
About this.
articulate and actually, I think you're doing a very good job. I don't think at this point you need to bring your attorneys in. But as I say, what we are looking at is a very narrow variance. And there are many, many hoops they have to jump through before they're going to be able to actually turn this into a short-term rental property. I mean, we can't deny
I
them.
bought my house with the existing use of that building.
Mhm.
Anything you change is gonna increase that use of that building, and my property value is gonna go down because of that.
Yeah. That we understand. We have,
Thank you.
Thank you.
thank you.
Thank you.
Yes.
Can you tell me when was the last time a variance was granted in Waterville Valley?
It's been a while. I can't, I would easily say it's been 5 years.
Now, a check of town record showed there hasn't even been an application in a decade.
Oh, no, that's not accurate.
Okay,
No. We've had a number of variances requests since then.
okay.
Yeah.
But not in 5 years, one hasn't been granted, you think?
When was the one about the horses? Does anybody remember?
Oh, that was.
a special use application.
Yeah, if you really want to know, but we can
Yeah.
find out.
It's just, it's an extreme thing to file for a variance.
Yeah.
I mean, there's a ton of building going on in Waterville Valley, because you can build, people don't need variance.
Yeah. But those have been, I presume, permitted under our zoning.
Oh,
laws.
sure, they're
Yeah.
permitted. Yeah, you can get it, yeah. Look at all the building that's going on.
Yeah.
It's all permitted. It's
That's
all
true.
within the existing rules.
Thank you, Mr. Wings.
Thank you.
Yes, Rich Rita would like to address the group. The board.
Rich Rita, 38 Snows Mountain Road. So I'm more than a little confused. First, I don't understand how you can consider a variance without considering the optimal use, the optimal purpose for that variance, not an intermediate step. But the question I have that relates to that, I think, is what is, I'm confused as to why a variance is even needed. What is the current status of this particular structure?
This particular structure right now is a non-conforming structure. It is
In what way?
too large a structure to be
For-
built within that 20-foot setback.
Correct. Okay.
If it were a much smaller one, as opposed to, I think it's 780 square feet, if it were only 150 square feet,
Right.
it could be built 10, the setback would be 10 feet, not 20 feet. But this one is much too large to do that. So they need to be able to turn this unoccupied structure into an occupied structure within the 20-foot setback. They need a variance from the setback.
If it's not an occupied quote unquote structure now, and I'm not sure there's even a definition for that in the zoning ordinance, what is it?
It is an accessory use, which would be considered under in low residential LDR. It would be considered to be an accessory building in the nature of a studio, which is permitted.
So it can already, so the applicant can already occupy the building for the purposes that are allowed in lower density
Right.
home occupation.
No,
No. And they can be used as what's called a studio as an accessory use. That's permitted in LDR.
stop.
No, well-
You're giving too much.
No, I'm just saying that that can, she wants to know why it can be used, and it can be used for that studio purposes, so that although that might be considered occupied, it is not occupied in the manner in which this is going to be.
What the ordinance says is that
Mhm.
structures have to be 20 feet from the property line.
Right, I understand.
It allows one unoccupied freestanding accessory building to
Right.
be 10 feet from the property line.
Right, of 150 or less.
Now it's
feet.
got to be 150
That was
square
new,
feet, but
right.
when it was built, it could be any size.
Right.
So that's what it was legal when it was built.
Right,
It is now non-conforming because it's too big.
right.
And for it to be occupied, it would have to meet the 20-foot setback.
So the issue is that It can't be used now because it's too big.
It can be used, it cannot be occupied. And I agree with you, I don't think occupied is
Defined in the
Defined.
No, it's
zoning
not.
no.
ordinance.
We're talking about a dwelling unit, not home occupation. You're
Right.
conflating the two terms.
Well, that's where I'm.
His
having
concern is a
difficulty.
dwelling unit.
Well, it
We're
is
talking about an
a dwelling or a dwelling unit, which are two different.
Yeah.
Which are two different things, and principal residence,
Mhm.
of course, as well. But I'm just trying to struggle to understand what is its use now then,
It's a workshop.
It was used as a workshop.
as a workshop, and
Yeah.
that is not considered an occupied,
It's
when-
considered an appropriate accessory use.
right?
When the building permit was issued, the
Right.
town did not feel that that was an occupied structure.
So is there a hole in the zoning ordinance? Is that what you're saying?
No, I'm saying there's been a change in the zoning ordinance since it was built. That when selectmen issue building permits, they need to make determinations. Here, they determined there would be no water, no sewer.
Right,
So it couldn't be occupied. No one could live there without a bathroom or a kitchen. And so they determined it was not
Okay.
occupied.
all right, I see what you're saying. This is where I'm getting confused because the conditions you listed for being occupied are dwellings or dwelling units. Not a studio or a garage or these sorts of things, which it could be used for now, right?
It could be used for
Yes.
various
And-
things now.
As
And
it was,
any of
but-
those
but-
things.
But the
So-
restriction on water and sewage would apply.
It can't have
Right.
water.
They
It
cannot
can't
have water or
so- but it
sewage.
can be used for the sorts of what we call, I think, home occupations. I could be wrong.
It could be
No.
used as a greenhouse, a tool shed, a
Yes.
playhouse, a home produce from a garden, garages, carports, studios, swimming pools, patios, and dog kennels. That sort of
And
thing.
it falls within, the studio is defined as an artisan type structure for use
Okay.
for that, and that's what the prior owner used it for.
It's possible this building cannot
Right.
be used for a garage. I was just reading the type of accessory structures that are permitted.
But it allows garages. I mean,
Yeah,
I know that was something that.
Under
we were working on.
LDR. Yeah.
So again, I'll end with my initial question, then how could you consider the variance for a setback if you don't consider what the ultimate goal of this is?
Can I tell you, I have struggled with that.
I know you
for
have.
A
I have
very
as
long
well.
time. Laura has tried to keep my focus on
Trying
what
to
we
keep
can
everyone in the
actually
right
do.
lane.
Thank you.
It's very, what we can do is very narrow. Is there anyone else who would like to? Yes.
Thank you. My name is Matt Rubin, and I live at 10 River Road, which is directly across the street from the property. And I also sort of take issue with providing a variance for this
Mhm.
because I take issue with some of the.
Could I ask you to speak up just a little,
Yeah,
please?
I take issue with some of the points that were made by the attorney earlier, primarily the one which doesn't impact property values and the character of the neighborhood. As it was pointed out, that structure is quite close to the adjacent property
Mhm,
as well as the street. This driveway, which is not a permitted driveway,
mhm,
faces towards my house. Having cars coming in and out
mhm.
would be lights directly into my house. That would affect value of my house. That would affect my enjoyment and the character of the neighborhood as well. I think one of the examples that was provided by the attorney, and I'm not an attorney, so I don't know the specific case, which was a case brought up before the New Hampshire maybe Supreme Court, that there was a property that you couldn't impose on a property that's applying for a variance, undue hardship. And the example was they couldn't deny a little enclosure over a compressor outside the back of the
Yeah.
house. This is a far cry from that.
Mhm.
And using that as an example was not at all sort of
Mhm.
imbalance.
Yes.
So I take issue with even providing that as an example, why it shouldn't be an issue. So I think in terms of the reasonableness, that doesn't meet the character, the requirement. Because as the attorney stated, reasonableness is one factor.
Mhm.
I don't think any of us here are trying to be unreasonable, but it will impact certainly the abutters. And being that I'm across the street, I consider myself an abutter. And it is very close. The fact that the approval for this structure is for, a studio or a shop, which is the development used it as a wood shop beforehand. It was only daytime use. Now we're talking about if it is a rental, if it is, then it's nighttime use. There are cars and lights and activity, and that does change the character of the neighborhood. And the other point that was made earlier is that this is such a unique property that nobody else would apply for, anything comparable to this. And I take issue with that as well. And one of the structures that the attorney did point out was up the street, I think it's to the north. And it's the Peckham's house where they have a garage-ish kind of a structure. And it has an upstairs in the garage, and that is close. And I don't see where this wouldn't establish a precedent for, if it weren't the Peckhams, the people who might buy the Peckham's place. And that's where the slippery slope is very much of a concern to me, and I'm sure all of the neighbors, because once this you start down this process, even though this might seem, it may not be that bad, it does set a precedent that can be problematic. And we moved into this neighborhood 20 years ago, even more. And for the very reason of it being a spacious, open, low density neighborhood, we very much appreciate the character of the neighborhood. And we dearly, dearly hate to see a change. Anyway, I think that's all I have to say.
Thank you.
Thank you.
Is there anybody else who would like to address any issues? Mr. Bolt, do you have any comments you'd like to make?
Just a couple, Madam Chairman. Thank you for the opportunity. One, I do apologize to the Nguyen's for them coming back. I believe they were contacted by my client well before this hearing. So there was a snafu by the town on some notices going out. But I welcome back, and I'm sorry for the intrusion. Keep in mind, as Attorney Spector Morgan indicated, you are here and you hear variances so that your zoning ordinance can stay in place. The court has said if you did not hear variances, there was not that play in the joints, your zoning ordinance would be illegal and would be wiped off for a taking. We are here because that's what the statute says is the proper route for us to be here. 674-33 says you have the jurisdiction over variances and you have those 5 criteria.
Yes, we have no quarrel with you on that.
And as I say in my my narrative, several cases have expressly said just because we're asking for a variance from a provision is not the reason for denying our variance. You only are here when somebody is asking for relief from a provision of the zoning ordinance. To hear that you haven't had one granted in 5 years is, I must say, rather unique. And part of my practice is representing towns. Part of my practice is here on behalf of private citizens. Part of my practice is for abutters. So it's one of those things that it's one where I hear the concerns, but our statutes are set up that this is the right route for the Gaudets to come in and seek the relief from the specific provision that your code enforcement officer said was the prohibition for the.
And that's, yes, we understand that. And
that's why we're here.
Yeah, I know. And that's what we're addressing. And I have tried to explain to everyone that we are not looking at whether this can ever be reconstructed as a short-term rental or reconstructed at all in any way or for any purpose, or whether the driveway will be permitted. All of those things will come before other town entities And anybody will have an opportunity to address them at that time also. Here we have a very limited, and I think that, well, anyway, we have a very limited review of what we're doing here today.
Sure. I'm happy to answer any other questions. If not, I'll take a back seat.
Okay, thank you. I have no further questions for you. Does anybody else?
If it's a
Well,
question
wait.
for me, we'll leave.
Yeah,
Okay.
wait for the- yeah, wait for this. No, if there's any other questions for
Hang on.
Mr. Bull. Okay. We're done.
Do
Thank
you
you.
have a question for me to tell you whether you have a question for him?
I just don't want to say out loud if I'm not supposed to.
You can say anything. We can talk to her first. Yes, we'll take a mini break. Actually, I'm gonna go to the bathroom. Next.
I'm hanging in there.
Glad you are.
I avoid all drinking 3 hours before meetings. What should I do?
On top of I will, and I'm not gonna. The shoreline is 8 feet off. It's a tough one. I read your brief. Very well constructed.
Yeah.
But it is one where.
Yeah, no, I get it, and I get it, so what they're deciding, it has nothing to do with coming down the road further on. I understand. I also want to.
Oh.